Houston. Can we talk about making some better decisions? Because so many of you out there make bad decisions, and it's one bad decision after another, and they kind of snowball, right? And they get bigger and bigger and bigger. And then when it gets to be the point at the moment of truth, you just have run out of rope because you've made so many bad decisions that justice cannot prevail. My name is Cory Roth. I'm a criminal defense attorney based in Houston, Texas. Practice across the state. And I just got out of court a couple hours ago for a client charged with felony possession of a weapon. In Texas, that's a crime that carries 2 to 10 years in prison and up to a $10,000 fine. There's a charge that's a little more serious. That's actually a second-degree felony that has very similar elements, so facts that the government has to prove. But in this case, my client is a hardworking young father, just gets off work, goes to his brother's house in west side Houston, gets some food. He's hanging out in the parking lot talking to an acquaintance of his, and this acquaintance decides to pop off maybe a whole clip from a pistol. My client doesn't want to be involved in any of that, so he drives off. And as he's driving off, a neighbor calls 911 and says, hey, there was this white Chevy Avalanche with a black guy with black dreads and a black shirt and black pants who just unloaded a clip, shot off rounds into the air. My client goes to the gas station. He's acting like nothing happened because he didn't do anything wrong. And that's where there's kind of like problems. And cops drive by. It's actually right across the street from a police station. And they immediately detain him. A whole bunch of cop cars. He's outside of his car pumping gas. And they immediately detain him. Where's the gun? I don't have a gun. There's no gun. I don't know about a gun. His windows are down. Doors open. One officer claims there's an odor of marijuana, but that's after the search. And all the other officers are like, Well, actually, the main officer asked my client, where's the gun? He goes, I don't have a gun. I don't know about a gun. And he walks over to the driver's side door. The door's open, and he says, nope. And then he sticks his head in, shines his flashlight, and sees a bag of marijuana and says, yup. So, we've got an issue, all right? The officer goes over to ask my client again, hey, where's the gun? We know there's a gun. The people are saying that there's a gun. We already found then they find a bullet casing in the car, and then they find a gun eventually, right? And then they search my client for a second time, and they find a bullet casing in his pocket. So there's 2 casings, a bag of marijuana, and a pistol with a full mag, and then there's an empty mag. Officers move my client to the police station. They start questioning him. They're acting cool, getting my client to relax. And folks, bad decisions, okay? When an officer's trying to be cool with you, it's not because he likes you. It's not because he's your friend. It's because he's trying to get you to confess. He's trying to get you to confess. And my client ultimately says, oh, well, I don't know, it's not my gun. It's my wife's gun. She owns it. Folks, it does not matter who bought the gun. It does not matter who the gun is registered to. It doesn't matter who owns the gun. That's not the issue in possession. In a possession case, the issue is whether you intentionally or knowingly exercise care, custody, control, or management over the gun. That's it. And, in this case, whether you're a convicted felon. So, this case troubled me for a really long time. It gave me a headache. Because I just had this feeling that there's a problem with it. My client was in the wrong place at the wrong time, and he ended up being arrested and charged. And it was a really crappy situation, to be honest, because a magistrate set bond. My client's family paid that bond. My client showed up to court on Monday, and the judge said, nope, your bond's insufficient. This young man ended up spending 3 or 4 months in custody when he didn't do anything wrong after being released on bond. Speaking of bad decisions, fast forward to today. I'm getting ready to set the case for trial, and there's a bond violation report. He had stayed out beyond his curfew probably about 20 or so times. Whether he was at work or whether he was picking up his children ultimately doesn't matter to a judge. What matters to a judge is, did you get her permission to do those things? So my client was in a place today. He was in a place today where it was either we go forward on this motion to revoke his bond and he's going to go to jail until his case is pending, or do you plead guilty? So I spoke to two prosecutors on the case. And I said, listen, here's the evidence that my client was working. He says, well, I don't care. But here's what I'll do. I recognize that there might be some problems with this case. I come from a time where we didn't give deferred adjudications in felon and possession cases. I'll offer 4. Your client will counter 2, so let's just settle on 3. And I said, listen, I appreciate that, but there are some serious problems with the case. And here's my legal analysis for you, the viewer. Someone calls 911. It's not an anonymous call. She gives her name, she gives her phone number, she gives her address. She explains very specifically what she saw, and my client very specifically and accurately matches that description. That call is going to give the officers a reasonable suspicion, a justification to believe that my client was possibly involved in the commission of a crime, and that the officers are justified in detaining him for the limited purpose of searching him for a weapon. And it's really more nuanced than that. At that point, the officers do not have probable cause to search his vehicle. The crime that was committed was a breach of the peace. There was no warrant. It was not a felony. It was just a misdemeanor, discharging a firearm within city limits. And without my client's consent to search the truck, and without the actual odor of marijuana or seeing marijuana in plain view from outside the car, there was no reason, justification legally for them to search the vehicle. So what they do is this officer pokes his head inside the car. When he pokes his head inside the car, that search becomes illegal. He broke the plane. That was a warrantless entry into his personal property, private property. It was an illegal search. So I say, hey, look, I think the officers have the right to detain my client briefly and question him briefly, pat him down for weapons briefly. But there's no probable cause to search the car. There's no warrant. It's an illegal search when the officer enters the car without consent, without a warrant, without the crime being committed in their view. So it's an illegal search. But even then, you don't have the affirmative links. Affirmative links are what is needed to convict somebody beyond 100% of the reasonable doubt of a possession crime. There's a list of 17 to 25 or so affirmative links. The most important starting place is that mere presence at the scene of a crime or within the area of an illegal gun or substance is insufficient. It's not adequate evidence to convict somebody. So I say, hey, look, listen to this. There's a bullet in my client's pocket that is the same color, or it's actually a casing, as the bullets in the full clip that is inserted in that gun. There's another shell casing on the passenger side floorboard that is a different color than all the other bullets in the car or in my client's alleged possession. Our story, my client's story, before we even knew that there was a different color shell casing in the car, was that this bozo friend of his was firing off rounds and a bullet exited the chamber, or whatever it's called, and landed in my client's car. And that's how that bullet got there. The two different colors makes it more logically possible that someone else was shooting, and that gun in the car is not my client's. So that's big point number one. Big point number two is that the gun was not in plain view. while it may have been within my client's reach, it was in some sort of a hidden compartment in the center console. Point number 3. That gun, if someone had just lit off 15 rounds 10 minutes earlier, that gun would have been hot. It would have been warm to the touch. It would not have been cold. Third, there was a full magazine in the gun. That indicates that nothing was fired, that gun was not touched. Fourth, they did not do a gunshot residue testing of his hands. That's the residue that would have been on him had he shot guns, or stippling. The burn marks from the gunpowder would have been on his clothing. They didn't do that test. And fifth, they could have also done fingerprint tests on the gun. This was a case there. I finally got that aha moment. And not every case you solve on the day it walks in your door. But this is a case where I finally got that aha moment. And unfortunately, my client put himself in a position where it was too risky to have the trial, because he didn't want to be in custody between now and whenever that trial is had. So here's the lesson, folks. Show me your friends and you show me your future. If you're hanging around with idiots who have bad habits, if you hang around with stupid people who like to fire off guns in residential neighborhoods, if you gangbang, if you're hanging out with a bunch of dope in your car, dope in your house, or friends who travel with dope, you're eventually going to get caught up in it, whether it's yours or not. I do not think my client knew that gun was in that car. He was not in possession of it. But he got screwed by the system, and he got screwed by himself today. So make better decisions. Make better decisions about who you hang out with, when you're hanging out with them, where you're hanging out with them. And hopefully that makes for a better life. Call me, reach me, contact me, make a comment. If you need my assistance. My name is Cory Roth. I'm in Houston, Texas. My number is 832-819-5290.